Welcome once again to Lehto's Law. Here's Steve Lehto.
We talk about qualified immunity quite a bit here, and a lot of people don't believe it. They simply don't believe that qualified immunity is that big of a deal. And whenever I talk about it, I invariably get 2 or 3 comments via email from people who are so troubled. They say, Steve, you understand, if we get rid of qualified immunity, no one will want to become a police officer. And so what you're really trying to do is you're trying to destroy the police departments. And I had a guy write me a really rude email the other day, and he actually said, Steve, you're just doing this to make money. You're doing this to make money. And he said that if qualified immunity goes away, I'll make money. He goes, because you're an attorney. Now, you understand, people don't just hand me checks and go, hey, Steve, a law changed. Here, have some money. It's not how it works. But number 2, I don't handle cases against the police. I handle lemon law cases. So if qualified immunity goes away, it's not going to make me any money. But I asked the person, I said, I'm just curious. Before qualified immunity existed, we had police. How come we could get police back then with no qualified immunity? Why do they need it now? And I got a response back. It's kind of like, oh, well, things were different back then. So you have to understand where the extreme cases are that prove that qualified immunity is borderline insane. So Tom sent me this note and said, Steve, check out this article that the Cato Institute published by J. Schweikert. And it's from the 10th Circuit Court. 10th Circuit grants qualified immunity to police who knowingly violated the First Amendment. The Supreme Court has repeatedly characterized qualified immunity as protecting all but the plainly incompetent or those who knowingly violate the law. So at face value, that standard of care is quite low, especially with respect to law enforcement. Now, the profession expressly charged with knowing and enforcing the law is law enforcement. So they should know the law. But the 10th Circuit Court's recent decision illustrates how this oft-repeated phrase is itself highly misleading. Because even when police officers do in fact know they're violating someone's rights, they can still receive qualified immunity. And the case is called Frazier versus Evans. The issue in the case is the First Amendment right to record police officers in the course of their public duty. Now, we've talked about this before, that some circuits have explicitly said you are allowed to record police officers when they're on the job. Several other circuits have not weighed in, and the U.S. Supreme Court has not yet clarified the issue. People go nuts when I say that, but it's true. So as Mr. Schweikert points out, the Supreme Court itself has not directly addressed this question. But the 1st, 3rd, 5th, 7th, 9th, and 11th, all the odd numbers, have all upheld the right. And some of these date back to 1995. Now, no circuit has ruled to the contrary. And in 2014, a group of Denver police officers violated the right when they threatened to arrest and conducted an illegal search of a man named Levi Frazier because Frazier had recorded them using excessive force in the course of making a drug arrest. Now, here's where it gets tricky. Since 2007, the city of Denver has trained its officers that people have a First Amendment right to observe and record the police in public. So their own training tells them people are allowed to do this. This training included multiple courses for officers, which the defendants in this case had completed a year before the incident. And there's a slide that they put up on the screen that says, citizens have a First Amendment right to videotape the actions of police officers in public places, and that seizure or destruction of such recordings violates constitutional rights. So it's not that the police just learn this stuff by osmosis. It's part of their training. They are trained by their supervisors at the police that this is what the law is. This is what we consider to be the law. This is what you should enforce as the law. So now that you know this, go out and do your job. Nevertheless, the 10th Circuit held that these officers were entitled to qualified immunity, even though at the time of the incident, 4 circuits had already held that such conduct was unconstitutional. This particular right was not yet clearly established in the 10th Circuit. So again, if it had happened in the 1st, 3rd, 5th, 7th, 9th, or 11th, court would have said, oh, qualified immunity ain't going to help you here. But since it happened in the 2nd, 4th, 6th, 8th, or 10th, the 10th, well, guess what? It's not a clearly established right. But the problem, of course, is that training these guys had. Shouldn't that count for something? So according to the court, the fact that the officers were explicitly on notice that their actions were unlawful was irrelevant. Frazier versus Evans is an important case for understanding qualified immunity because as appalling as the outcome is, it's not obvious the panel's decision was actually at odds with current doctrine. And that's what we've been saying before, is that to show that the police are acting out of line, you've got to prove that there was a case in their circuit on point that shows what they're doing is wrong. Doesn't matter if it's a circuit next door. Doesn't matter if you're trained and told this is what the law is. Doesn't matter. Somehow, police are only required to follow binding legal precedent, but not their own training following this logic. This case illustrates how qualified immunity applies not in an exceptional case, but in a typical one. And is therefore an instructive primer on nearly all of qualified immunity's perverse features, considering the following basic tenets of qualified immunity and how they're applied in this case. As noted above, when Denver police officers violated Levi Frazier's First Amendment rights in 2014, 4 circuits had already held that such conduct was unconstitutional. But the 10th Circuit panel here dismissed any reliance on those cases because those decisions do not indicate that this right was clearly established in our circuit. In theory, the Supreme Court has indicated that a robust consensus of cases of persuasive authority can clearly establish a legal principle for the purposes of qualified immunity, but apparently the uniform out-of-circuit authority here was insufficient. And that's one of the things that I get asked a lot about. People say, Steve, I found a case that says such and such, and it's a court of appeals opinion from a different circuit. Is that good law? They say, well, is there case law on it in your circuit? The answer is no. Well, that's good law, but it's not binding on your circuit. But if you're arguing the case in your circuit, you can point to the neighbors and say, well, the learned brethren and sistren of the nearby circuits have ruled thus, and I believe we should follow that rationale. But they don't have to. And that often happens where different circuits come to different conclusions, and that's when a case goes up to the Supreme Court. I'm surprised the Supreme Court has not weighed in on this one yet because of the fact that you have those opinions all out of the odd circuits that have ruled explicitly, and just strangely, none of the even circuits have. So, nor was it relevant to the 10th Circuit. The Department of Justice, the City of Denver, and the police departments around the country had also explicitly instructed their officers that the First Amendment protects the right to record the police in public. As the panel explained, judicial decisions are only valid interpretive source of the content of clearly established law. So, the court says, look, we don't care what anybody says. We don't care if the Department of Justice, we don't care if your own training says so. We don't care what the city says, what your boss says. We don't care about any of that. All we care about is there a precedent in this circuit by this panel saying that what they're doing is a clearly established law that's being violated? And the answer to that is there's no such precedent. Then guess what? The cops can do whatever they want, regardless of their training, regardless of what they've been told by the Justice Department. Doesn't matter. So, in principle, of course, the U.S. Supreme Court could take a case on the question and issue a decision clearly establishing the First Amendment right nationwide. The problem, however, is the Supreme Court only decides a small number of cases every year, and most of these are limited to resolving circuit splits. And in this case, the First Amendment right at issue is sufficiently clear that there is no circuit split. Every court that addresses it agrees. And that's the argument that I've heard many times, and there's merit to it, but it's not what we'd call dispositive. Because every court that's ruled on it has said, yes, we agree with this. We agree that it's a First Amendment right to videotape police officers or to film them or to digitally record them. Okay? But the other ones haven't ruled. Now, you might say, but Steve, it's obvious that the trend is that they're going. No, we don't know that. And once in a while, weird things happen. It does seem odd to me that it's 1, 3, 5, 7, 9, and 11. That's strange. That's really strange to me. But that doesn't mean that the evens won't go the other direction. Doesn't mean that. But it does seem that that's the trend. You know, if you just look at wins and losses right now, the argument for the First Amendment on this appears to be winning. It's undefeated on that topic. But until the other circuits rule, you can't say that. And of course, the Supreme Court might not weigh in because they're looking at it going, well, it's obvious that everyone should get this. But I would think that with the amount of writing and complaining and video blogging about this, that they might say, you know something, maybe we should end this once and for all and make a ruling on it. So in light of qualified immunity, this leads to the perverse result that the uniform consensus of many circuits on a particular right actually makes that right less likely to be protected in other circuits. If there was a circuit split, the Supreme Court might resolve the issue nationwide. But without one, courts can continue saying, as the 10th Circuit did in this case, maybe it's clearly established over there, but is not clearly established here. And the evidence in this case overwhelmingly demonstrated that the Denver police officers who harassed, threatened, and searched Levi Frazier knew they were violating his First Amendment rights. As noted above, the city of Denver had instructed its officers on the right to record police since 2007, and the defendants here had taken a course covering exactly this subject just a year before the incident. The record also plainly supports the conclusion that the officers' subjective motive was retaliation against Frazier for recording them. One of them actually yelled, "Camera!" as Frazier recorded them using force on an arrestee. The officers followed Frazier to his van and demanded both his identification and the video. They threatened to arrest him after he refused to volunteer his video. They illegally searched his tablet for the recording, and they let him leave only when they thought he did not have any video recordings of them left. So this is about the most damning evidence one could ask for, that these officers were acting in bad faith and knowingly violating Frazier's rights. One could thus be forgiven for thinking these officers shouldn't receive qualified immunity, given the Supreme Court's repeated insistence that qualified immunity does not protect those who knowingly violate the law. But as the 10th Circuit's decision here makes plain, the way courts conceptualize what it means to knowingly violate the law is nothing like what an ordinary person would understand that concept to mean. The article is 5 pages long. I'm not going to read all 5 pages of it. It's an excellent article. And now many people are going to say, well, Steve, you know something, this guy's probably a First Amendment auditor and he's on the sidewalk and he's filming something and it somehow bugs the cops. This really isn't that big of a deal compared to like when the police steal money from somebody or blow up their house looking for a suspect, or when they lock a guy in a prison cell that's, inhumane, and that's when the Supreme Court actually said it was so obvious they didn't need a ruling on. And it's like, but wait a second. What does it mean to knowingly violate somebody's rights? To knowingly violate somebody's rights. And the Supreme Court and the courts of appeal appear to be saying that, well, the only thing you need to know is what the current state of the law is in your circuit. So in your circuit, you would then study all the case law. And if there's case law on point and you then violate it, well, then they can say, well, yeah, case law on point. But are police really supposed to be doing legal research of cases in their circuit? Or should they, understand their training? Isn't their training something they should know? And this is an example I've mentioned before, where judges who've been on the bench for decades, often are on the bench for a few decades too long, and they lose sight of the just plainly obvious, that most people, when they hear that the police have qualified immunity, and the qualified immunity protects them from legal actions because they have to violate somebody's rights knowingly and all this, and it's got to be a clearly established right, most people kind of go, well, I kind of understand why you don't want cops being sued for everything. And that's like people's emails I get, the angry emails I get. They go, well, Steve, then you just sue a cop for anything. No, you just sue a cop for anything, it'll get thrown out. You got to sue him for violating your rights or something. Cop pulled me over, I'm going to sue him. No, that won't work. No one's advocating that you should be allowed to sue the police for just everything and anything you want to, okay? What we're talking about is you should be able to go after the police if they violate your rights, okay? And then the question simply becomes, what is that? So the idea behind qualified immunity actually makes a little bit of sense, okay? It's just a question, where do you draw the line? And the problem is they've drawn the line so far off the scale that it's almost impossible for the police to ever be held liable for it. And so when you hear that, we're talking about them having knowledge, knowing that they're violating somebody's rights. The question is, what does it mean to know something? And that is such a primary, elementary thing that most people know what it means to know something. And so when you ask a police officer anywhere in America, there's someone standing over there on public property, okay? The only thing they're doing is they've got a camera or a device that records video, whether it's a phone or a tablet or a video camera or a VHS tape camera, okay? It could be a Super 8, but they have a device that records motion pictures of some sort. And they're filming something that's happening in a public space in broad daylight. Most police officers, when asked the question generally, person's 100 feet away doing that, they're in public, just doing that. is what they're doing illegal? Most cops go, no, of course not. It's not illegal. Everyone knows that. Okay? So what happens, though, when the police are doing something they shouldn't be doing to somebody else and they realize they're being filmed? Camera! Well, the guy who yells at camera is not yelling it out because cameras are illegal. They're not illegal. But they realize that they've been filmed doing something they shouldn't have been doing. So they retaliate against the guy. As they're retaliating against that guy, do you think they know that a guy's allowed to stand there and film them? Remember, I asked you a minute ago, just a general question, do police know this? Of course they know this. They were trained on this. They took sessions and classes on this where there's slides up on screens, they're taking notes, and one of the things says, citizens are allowed to record you while you work. They're allowed to do that. That's a First Amendment right, and that was part of their training. So the fact that they were trained in something, assuming they're competent and they know what they're doing, they have an ability to learn, they know this. So the fact that a court of appeals says, well, they were trained, they were told this, but we, the 10th Circuit, have never opined on it and have never ruled on it in such a way. Therefore, they're not liable for this. They get qualified immunity. And so what they did to this guy, he can't sue him for. It's crazy. And most people would agree with that. So for all the people to be tempted to send me emails right now saying, Steve, you hate the cops, go read the comments underneath my how to behave during a traffic stop video and read all the comments from the people who say that I love cops. And maybe you guys can just get together and debate amongst yourselves. But number two, we had police before 1967. And 1967 is generally what's considered to be the beginning of qualified immunity in America. So if we had police before 1967, how do we get them? If it's impossible to do your job unless you get qualified immunity. How is it possible? How we had cops back then. Now, I'll admit, I hadn't been around for a long time in 1967, but I'd been around. And in 1967, I knew what a cop was. They didn't have qualified immunity. Somehow we had cops, though. I remember seeing a cop come to my elementary school. Didn't have qualified immunity. Put in a little demonstration. He had a bicycle. Told us about bike safety. How to cross the street. Cop did not have qualified immunity. And somehow he was happy. He had a job. He was happy. And I remember as a small child looking up to the guy, uniform, going, wow, that's who you go to if you need help. That's who you go to if you have a problem. If you see him, that's someone you can go to, right? And didn't have qualified immunity. Did not have qualified immunity. So I don't hate cops. And people who want to do away with qualified immunity don't hate cops. We hate the really bad policy of qualified immunity, which says that cops don't have to know the law. And even if they do know the law, we won't hold them liable for it because of some convoluted thinking that no one understands. So there you go. Tom, thanks for sending it. Jay Schweikert wrote it for the Cato Institute. It's a fascinating article. I'll put a link to it in the description below. 10th Circuit grants qualified immunity to police who knowingly violated the First Amendment. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Make time for people who need help, regardless of whether they are friends or not.